We're on to present estates, level 3 in our levels system, in a series that we're calling Mastering the Law of Property using the levels system. Again, if you like this video, then hit the like button and subscribe to the channel. If this is helpful to you, but you're looking for a briefer review of the entire law of property, then check out our website, barsecrets.com, and look at the product we have there called Power Law. On to present estates.
The next big level 1 topic is present estates. And in a way, it's hard to talk about present estates without talking about future estates. So I'll do the best I can, but I will refer to future estates. It's somewhere along the line here.
And I'll bother you when I don't understand.
Okay, all right, because this seems to be the area of property law that confuses a lot of first-year law students. And because of that early confusion, they develop a distaste for this area of the law. And then, when faced with it on the bar, resist it.
I think it's almost like that math anxiety. We get such a negative feel for this in first-year law.
Yeah, the truth is it's not that difficult. So let's see if we can't demystify this. First, we begin with a fee simple absolute. This is an estate that runs forever, has no limitations on inheritance or alienation, so you can devise it and you can sell it, and it runs forever. Now, what about estates that may not run forever? This is where we have to deal with the problem of future interest, because if the estate doesn't run forever, we always have to account for all the interests. So if it doesn't run forever, what is going to happen? Now, these estates that have the potential of infinite duration, just like a fee simple absolute, but where the interest may terminate on the happening of some event, are called defeasible fees. And there are 3 kinds of defeasible fees: fee simple determinable, fee simple subject to a condition subsequent, and fee simple subject to an executory interest. These are the 3 present estates that you want to keep in mind and that you want to distinguish. Now remember, if the estate gets cut off, we have to account for, well, what's going to happen after that point? And the what's going to happen after that point is the future interest. In other words, suppose there is that event that cuts the duration of that fee. Who continues? Who takes over at that point? And this is called our future interest. Now, in terms of defeasible fees, we have 2 types where the future interest is retained by the grantor. In other words, the person giving the land, making the conveyance, retains some interest in case there's a happening of the event. In the third type, fee simple subject to an executory interest, a third person, someone other than the grantor, takes over upon the happening of the events. That's one big distinction. Does the future interest go to the grantor, or does the future interest go to a third party? Let's look at fee simple determinable. This is limited by durational language. Let me give you an example. To John, so long as he stays married to Mary, my beloved daughter. All right, now that might be the kind of conveyance that may have been made back in medieval times. So that's a good way for the grantor to ensure that his daughter is going to stay married to John, and John won't leave, because the minute John leaves, then he loses the property. Now, remember, durational language, so long as, while, until. Now, one of the points about this is the future interest is held in the grantor. And that future interest is called the possibility of reverter. The other important thing to remember about this fee is it ends automatically. In other words, let's say John leaves Mary. The second John leaves Mary, at that very second, that's the event, it's triggered, and the estate reverts back to the grantor's estate. Now, remember that such fees are freely transferable. And also remember that whenever the future interest is held in the grantor, the interest is not subject to our good old friend, the rule against perpetuities, or RAP. And we'll talk a little bit more about the rule against perpetuities in just a bit, but the rule against perpetuities is a rule designed to prevent what we call remote vesting. In other words, the rule against perpetuities wants to have some stability. It doesn't want to have someone have land and give it to that person's heirs for generations after generations, and then maybe in 100 or 150 years, up pops someone saying, well, the events happened, that's mine, I want it. So we need some stability, and the rule against perpetuities provides that, but not for fees where the future interest is held in the grantor. So that's important to remember.
So this is pretty simple so far.
Mm-hmm.
I mean, as far as certainty goes, both of these are pretty certain. The simplest one was the fee simple absolute.
Mm-hmm.
But this fee simple determinable, I never thought about it in first year law, but of course it's called determinable because if the event happens, it goes back to the grantor. We always know who holds the interest.
Right. So in other words, we can always determine who owns the interest. Now, fee simple subject to a condition subsequent means you hold the fee simple unless some condition occurs. And the way these are formed is they use the conditional language such as but if. So we could change that and say to John, but if he should ever divorce Mary, then I, the grantor, have the right of entry. Now notice that the grantor, as indicated, holds the future interest. Now here, the future interest is different. The future interest is the right of entry. So that means the grantor has the right to go in and reclaim the land. However, unlike your fee simple determinable, the fee simple subject to a condition subsequent does not end automatically. The grantor must affirmatively demonstrate his intent to terminate the estate. As with your fee simple determinable, these are freely transferable, and they, again, because the future interest is held in the grantor, it's not subject to the rule against perpetuities.
So determinable, when that happens, when whatever this is, the until or the so long as happens, now it goes back to the grantor automatically.
Right.
But this subject to condition subsequent to John, but if he ever leaves my daughter, then I have the right to re-enter.
Right.
Well, when John leaves the daughter, now we don't know who holds Blackacre because the grantor could choose not to re-enter, right?
That's exactly correct.
So he could leave it as it is, or he could walk in and take it back.
That's right.
Okay.
That's right. And John could divorce Mary, and Mary could stay on the property, and John could stay on the property, and the grantor could sit there and do nothing through the statutory period for adverse possession, and then John and Mary would become co-tenants via adverse possession.
Okay.
Fee simple, subject to condition subsequent. Now, like your fee simple determinable, the future interest is held by the grantor. Now, this particular fee the future interest is called the right of entry. Now, let's compare the right of entry to the future interest in a fee simple determinable, the one we just talked about, where the grantor holds the possibility of reverter. In the possibility of reverter, upon the happening of the event, the interest reverts back to the grantor automatically. But in the right of entry, the grantor must affirmatively demonstrate the grantor's intent to terminate. So the interest doesn't terminate automatically. It will only terminate if you have two conditions, actually. Number one, you need the event, and number two, you need the grantor to take some affirmative action. So, how do we form these? Essentially, we form them by using conditional language. Notice fee simple subject to condition subsequent. So we use conditional language, but if. To John, but if he should ever get a divorce from my beloved daughter Mary, then I have the right of entry as grantor.
So, I never thought about it in first year property. I think I was too busy trying to figure out what the heck this whole scheme was.
Mm-hmm.
But you started with something very simple, and that's what it was called, a fee simple.
Mm-hmm.
Well, one person owns it. It runs forever.
Mm-hmm.
You move to a slightly more complex thing. You move to a fee simple determinable, but there was still a lot of certainty there because it had the durational language, and when that duration was over, we knew it went automatically back to the grantor.
Yeah, upon the happening of some event.
Yeah. And now we move to one condition subsequent that's less certain because it has conditional language, but it sounds as if the grantor can choose to take it back or can choose to let it just stay the way it is when that condition happens.
Yeah, yeah.
So that's, it never occurred to me that fee simple determinable, the reason it's called determinable is because it's set in stone.
And condition subsequent has a condition subsequent in it. And it's not too bad once you start keeping these interests straight in your head. Remember, because the future interest is held in the grantor in a fee simple subject to condition subsequent, it's not subject to the rule against perpetuities. And as with other fees, these are freely transferable. All right, now we come to fee simple subject to an executory interest. In this one, upon the happening of an event, the interest does not revert to the grantor, and the grantor has no interest. Instead, the interest shifts to a third party. So how can you tell the difference between where the grantor has the future interest or there's a third party? Easy. The conveyance will mention a third party. If there's no third party mentioned, then you just assume it goes back to the grantor. But if there's a third party mentioned, now you know you have these executory interests. Now, these fees automatically, so we have automatically divests in favor of a third party upon the happening of an event.
So is this durational language or conditional language?
It's either. It's either. And that confuses a lot of first-year property students when they start seeing, well, first they get used to the determinable fees and versus fee simple subject to condition subsequent, and they see there's a language difference there that distinguishes the two. And all of a sudden you come to your executory interest, and the durational language or conditional language doesn't matter. It's the presence of the third party, not the grantor, that makes all the difference. So that's what you have to remember.
So if I were thinking this out, aside from a fee simple absolute, if I've got something other than a fee simple absolute, probably the first thing I want to pay attention to is whether it would go back to the grantor or to some third party. That's the first thing I need to distinguish.
That would be a good thing to distinguish.
If it's to a third party, we've got subject to executory interest.
Yes.
If it's to the grantor, now I have another decision I need to make. Is it conditional language or durational language?
Exactly.
Okay.
Exactly. Now, these fee simple subject to an executory interest terminate upon the happening of the event. So we could say to John, as long as he stays married to Mary. But if he doesn't, then to Bill. Notice I have a third party in there. So Bill has an executory interest. And we could do it the other way. To John, but if he ever divorces my beloved Mary, to Bill. It's that third party that distinguishes these executory interests. And they terminate automatically. So the minute John leaves Mary, Bill is the true owner. Freely transferable. But unlike the other two fees that we've discussed, this one, your fee simple subject to an executory interest, is subject to the rule against perpetuities.
Uh-oh.
You see, where the interest goes back to the grantor, we know that the property is always going to stay within the grantor's heirs or according to the grantor's wishes. But where some third party may take, this is where we really don't want remote vesting, because generations can go by and all of a sudden there comes someone not in the family to take over. And we don't want this to happen, and that's what the rule against perpetuities is all about. Now, we'll come back to this rule against perpetuities because it's the puzzlement of many, many law students. It's not that difficult. Well, it is that difficult. And because it's that difficult, you don't have to worry about it as much. So we'll see. Now, the next present estate I want to talk about is a life estate. This is an estate that terminates at the death of someone. So I could say life estate to Nancy in Blackacre. That means that Nancy holds Blackacre throughout her entire life. Now, if I don't mention what happens afterwards, then I, as the grantor, would take upon the death of Nancy. And the
Or your heirs would.
Or my heirs would if I'm no longer among the living. Yes, yes. Whoever inherits my interest and the grantor's future interest is called a reversion. Now, sometimes, actually more frequently, the grantor says to Nancy for life, then to, say, her daughter. Well, her daughter would have a remainder. That's called a remainder. We're going to come to that next. However, the grantor would still maintain a reversion. The reason the grantor has a reversion is, well, what happens if Nancy and her daughter, which is a fictional daughter, I know you don't have a daughter, but her fictional daughter, Nancy and her fictional daughter die simultaneously. We still have to have someone there, and the grantor would be the one, and the grantor would still hold the reversion. Now, there's some issues on life estates. Remember that this is how they're formed. Anytime you get a conveyance that says to anybody for their life, that's it. You've got a life estate. Don't be fooled by something like to Nancy and Bill for life, and then to the survivor of them. To Nancy and Bill for life means each has a life estate. Just because the words and then to the survivor of them, that's not the same as rights of survivorship. So that's not a joint tenancy.
That one might also read, to Nancy and Dennis for so long as they both shall live, and then to the survivor of them.
Mm-hmm. In either way. And as you're going to learn, what's left over, each has a life estate and each has a contingent remainder instead of a remainder. And we're getting a little bit ahead of ourselves. So we're going to discuss these future interests in just a second. But let's just finish up on life tenant. The life tenant has to pay taxes, make repairs, pay for water, and pay for interest on principal. The big issue is waste. The life estate tenant cannot commit waste. That means you must maintain normal use. You must use the land according to its character. If the land is a farm, when the life estate tenant moves on, the life estate tenant must treat it as a farm. If the life estate tenant discovers oil, the life estate tenant is not permitted to drill for oil.
But will in a law exam hypo or in a bar hypo.
Okay, and then therefore that's waste. And if there's a remainderman, the remainderman can have standing to sue. The suit would not deprive the life estate tenant of the life estate tenant's interest, but can get an injunction to stop that conduct. All right. The life estate tenant does not have to insure the premises. The holder can only transfer his or her own interest. So if I have a life estate, it's only as good as I live. That means that I cannot will it away because the minute I die, it's gone. That's important to remember.
So you can only transfer what you hold.
That's exactly correct.
So if you have a life estate, sure, you can sell it. You can sell that life estate.
You can sell it.
But at the moment of your death, whoever bought it now owns nothing.
That's right. And it's not subject to RAP, so life estate is another one not subject to RAP. So if you're worried about RAP and you don't know a thing about it, at least you could know where RAP applies and where it doesn't. That'll get you half the way there anyway. Now, life estate per Arthur V means a life estate to one person measured by the life of another. So let's say we have a husband and a wife, and the husband's 20 years older. So say we have a life estate to Dennis measured by the life of Nancy. That would mean that Dennis would own for as long as Nancy shall live. And that's that life estate.
That's one way to think about the one we mentioned earlier, to Dennis and Nancy for as long as they both shall live, and then to the survivor of them. You might think about that in terms of a life estate per Autre vie.
Mm-hmm.
It's literally the life estate is measured by the life of the other person.
Yeah, you could.